Yep. If you want to get started, I'll give you hands.
Hello everyone. Welcome to today's Real Estate Institute of New South Wales webinar. The topic is REIT Workplace Health and Safety. We're pleased to welcome our presenter for today, Greg Patterson. Greg Patterson is the former Executive Director of the Real Estate Employers Federation, REIF. He's an experienced industrial advocate, negotiator and employee relations advisor, having been involved in industrial relations at both national and state levels for many years. He was the 2013 recipient of the REI NSW Woodrow Waite Award for Outstanding Service to the Real Estate Profession. This webinar is live and interactive. You are encouraged to participate by posting questions to the presenters via the chat box, which is located at the bottom right corner of the screen. If you're experiencing any difficulties, such as loss of sound during the webinar, please dial 02-8267-0515. This number is also located in the chat box. Now I'll pass you to Greg to begin the webinar.
Yes, thank you, Josh, and good morning, everybody, and thank you for joining me this morning to look at the topic of workplace health and safety. When I was putting the employment program together for these webinars and face-to-face courses, I thought that this would probably be the topic that would attract the least interest. But pleasingly, I've been advised that there have been significant registrations for today's program. The reason why I make that observation about workplace health and safety attracting limited interest is that traditionally, when we've covered this topic in our REIF forums, we found that members haven't been terribly interested in it because, understandably so, because we don't operate in a dangerous environment. We don't deal with dangerous machinery, chemicals or plant. And the general day-to-day activities and work performed in real estate is not dangerous to the extent that it is in other industries such as mining, manufacturing, transport and so on. But it is still, there are still activities that we undertake in real estate that carry risks, and of course the work health and safety laws provide that every business has a responsibility to ensure the safety of their workers. So thank you for joining me this morning, and as the first slide shows, workplace health and safety is everyone's responsibility, and I hope that that's the message that I carry through this presentation, that it is not simply a responsibility for the owner of the business, it's the responsibility of everybody in the business. So in terms of the presentation, because of the legislative framework within which this topic sits, we're going to have to cover off on some of the legislative background so that we can then apply the practical applications to that background, and hopefully then the practical applications will be better understood. So I apologise to the extent that the first part of this presentation will be driven very much by the framework and the legislation, but it is important we understand that so we can then apply practical situations to it. So just a couple, and there's only 5 of them, 5 words or phrases I'd like to cover off because they'll be constantly used during the course of the presentation. The first one is when I refer to the Act, I'm talking about the Work Health and Safety Act of 2011, which commenced operation on the 1st of January 2012. So that's been in place now for 4 or so years. I would indicate that the Act that I'm going to be referring to is the New South Wales Act. However, the laws have been somewhat harmonised across the different jurisdictions, so all states and territories are eventually going to enact legislation which is primarily based upon the national principles contained in this Act. So if you were watching this from somewhere outside New South Wales, you'll still find that it has practical application to you. The second phrase or second word is the acronym PCBU. It stands for a person conducting a business or undertaking. It's used extensively throughout the Act, excuse me, and therefore I think it's important that I at least define that term at the very beginning. The term worker is fairly broad. We, of course, in a general sense, accept that worker means someone employed within a business. Well, it's a bit broader than that. Under the Act, it talks about any person who carries out work for a PCBU, that's a person conducting a business or undertaking, including work as an employee, work as a contractor, work as an employee of a contractor or a trainee, and so it goes on. So it's quite extensive. Workplace, similarly, can be fairly broad in its interpretation. Workplace could be any place, or is any place, where work is carried out for a PCBU, and includes any place where a worker goes or is likely to be while at work. And for purposes of real estate, if I can drill down and be specific, that of course would include a motor vehicle. And lastly, the last phrase for definition is the term reasonably practicable. And I will deal with this in more detail when I come to slide 5. So just very quickly, the Act. The Act is called the Work Health and Safety Act 2011. It commenced on the 1st of January 2012. There are 14 parts to it. There are 10 regulations and 20 practice. Now, clearly, that's extremely extensive. The Act and the regulations and the codes of practice fill up, quite a few volumes of folders. So it's not going to be possible, of course, to cover off all of it. In fact, it'd be a waste of time to try and cover off on all of it. I'm going to try and cherry pick the parts of the Act and codes of practice which I believe are more relevant to the people who will be viewing this webinar. The main objective of the Work Health and Safety Act is to provide for a balanced and nationally consistent framework to secure the health and safety of workers and workplaces by protection from risk by elimination or minimisation of that risk, by introducing consultation and issue resolution, encouraging unions and employers to promote improvements in work health and safety practices, and securing compliance through effective enforcement. And we'll talk about each of those in the course of today's presentation. Now, there are some general duties under the Act. That a duty is imposed on a person to ensure health and safety requires the person to eliminate risks to health and safety so far as is reasonably practicable. Now, I've highlighted the words or the phrase reasonably practicable, and I'll deal with it in the next slide, but that's the first duty imposed on a person. And the second duty is, if it is not reasonably practicable to eliminate risks to health and safety, then you have to minimise those risks so far as is reasonably practicable. So if I could give perhaps just here to interrupt here and give an example of what I would be referring to here. It may well be that a real estate salesperson is going to be showing property or going out to list property or to show property to purchasers or to show property to potential tenants. Now, it may well be that at the place that is to be sold or is to be tenanted, that will become a workplace for that work for your employee, for your salesperson or your property manager when they conduct any inspections. Now, it will be absolutely impossible to ask the owner of the property to eliminate a potential risk that's been identified. Maybe the balcony or the steps are wonky or slippery or whatever. You have no ability to completely eliminate that, but you may have to take steps as far as reasonably practicable to minimise the risks that may be suffered because of that perceived hazard. Reasonably practical means that which is or was at a particular time reasonably able to be done in relation to ensuring health and safety, taking into account and weighing up at all relevant times things such as the likelihood of the hazard or the risk concerned occurring, the degree of harm that might result from the hazard or the risk, what the person concerned knows or ought reasonably to know about the hazard or the risk, and the ways of eliminating or minimising the risk, the availability and suitability of ways to eliminate or minimise the risk, and after assessing the extent of the risk, the available ways of eliminating or minimising the risk, the costs associated with available ways of eliminating or minimising the risk, including whether the cost is grossly disproportionate to the risk. So, in other words, the appropriate people in the business need to examine and evaluate what hazards and risks might be confronted and what the costs might be of eliminating or reducing those risks. I'll give an example there. Let's assume that we identify that there's the risk that when a person goes out to meet a prospective purchaser at a property, there could be the risk of entrapment and assault. And one way that you might identify as minimising the risks of entrapment or assault might be to say only 2 people can attend for that particular inspection. Now, that might not be reasonably practicable in the circumstances of the business to have 2 people attend that inspection. But that is the sort of examination that's expected of businesses once a risk or a hazard has been identified. A PCBU must ensure, so far as is reasonably practicable, the health and safety of workers engaged by the person. A PCBU must ensure, so far as reasonably practicable, that the health and safety of other persons is not put at risk from work carried out as part of the conduct of the business or undertaking. An example there might be if you had somebody come in to perform some work as a contractor in the business, perhaps they're doing some renovations or doing something within the business, and not only do the workers of the contractor who's performing the work need to be protected as far as reasonably practicable against any risks, but so do your own employees. So that's why you'll commonly find that many activities might be undertaken outside of ordinary work hours. A PCBU must also ensure, so far as is reasonably practicable, the provision and maintenance of a work environment without risks to health and safety, the provision and maintenance of plant and structures, the provision and maintenance of safe systems of work, the safe use, handling and storage of plant structures and substances, the provision of adequate facilities for the welfare of workers, including access to those facilities. I'll come back to that very soon. The provision of any information, training and instruction or supervision that's necessary to protect all persons from risks to their health and safety. The provision of adequate facilities for the welfare of workers, including ensuring access to those facilities. The provision of any information, training, instruction or supervision that's necessary to protect all persons from risks to their health and safety. Now, one of the codes of practice concerns managing the work environment and facilities. And it deals with things to do with lighting, with layout of offices, to do with toilet facilities, wash basins, lunchrooms, etc. Now, a question that comes up from time to time is, what sorts of facilities do we have to provide? There's no real set provisions to that extent, but the legislation, as you can see there, says that you have to be able to provide adequate facilities for the welfare of workers, including access to those facilities. So if your office, for example, was in an arcade or a shopping centre, it may be that you don't have your own toilet facilities, that staff have to use the external public facilities. Now, in the circumstances, that is probably quite sufficient. But it is a case that each matter would have to be assessed on its own set of facts and circumstances. But I would strongly suggest that if you are interested in this particular issue of welfare of workers in terms of facilities, that you download from the WorkCover website a copy of the Code of Practice headed Managing the Work Environment and Facilities. You'll find that gives you some significant guidance as to what you should be looking at in terms of matters inside your office. The primary duty of care also applies to those with management or control of workplaces. In other words, under the Act, it's not just the directors or officers of the company or of the PCBU that are responsible. It could be management, someone with managerial responsibilities or control over that workplace who also has a duty under the Act. If a PCBU has an obligation or duty under the Act, then a director or officer must exercise due diligence to ensure that the PCBU complies with that duty or obligation. And due diligence means taking reasonable steps to acquire and keep up-to-date knowledge of work health and safety matters, to understand the nature of the operation, of the operations of the business or undertaking of the PCBU, and generally of the hazards and risks associated with those responsibilities. To ensure that the PCBU has available for use and uses appropriate resources and processes to eliminate or minimise risks to health and safety. To ensure that the PCBU has appropriate processes for receiving and considering information regarding incidents, hazards and risks, and responding in a timely manner to that information. To ensure that the PCBU has and implements processes for complying with any duty or obligation under the Act. For example, consulting with workers or how they have to report notifiable incidents. And finally, to verify the provision and use of the resources and processes referred to previously. So you can see from those last two slides that there are significant responsibilities imposed on directors and officers in relation to due diligence around work health and safety. And of course it's always a fear that if directors and officers don't take work health and safety seriously, or serious to the extent that they recognise their responsibilities, then should something happen, then there are going to be consequences because due diligence was not followed by the directors and officers. And we'll talk about what those consequences could be very shortly. But, and I think this is a very important point to make, there are duties imposed on workers as well as directors and officers. Now, under the Act, a worker must take reasonable care for his or her own health and safety. Take reasonable care that his or her acts or omissions do not adversely affect the health and safety of other persons. So if a worker becomes aware of a hazard, then there is a responsibility that worker makes other people aware of that hazard. A worker must comply so far as the worker is reasonably able with any reasonable instruction that's given by the PCBU to allow the person to comply with the Act. So if you impose some standard or expectation or policy that you expect the employee or the worker to follow, they must follow that direction. And failure to follow has serious implications. A worker must cooperate with any reasonable policy or procedure relating to health and safety at the workplace that has been notified to workers. And this is a significant change to the old Act that was in place prior to 2012, where the onus was almost exclusively on the directors and officers of the business to ensure the health and safety of workers. The as far as reasonably practicable test wasn't in that old Act, and nor did workers have this same statutory responsibility that appears in the 2011 Act. So we see that at least as a significant boost in the fairness or the the equality around the responsibilities to health and safety in workplaces. What are the penalties? Well, penalties are divided into three categories. Category 1 offences are the most serious, and that involves reckless conduct. If a person without reasonable excuse engages in conduct that exposes a person to a risk of death or serious injury, and the person is reckless as to that risk, well, the penalties are $300,000 and 5 years in jail, or 5 years and/or 5 years in jail for an individual. For a director, $600,000 and/or 5 years in jail, and for a company, $3 million. I don't think we're likely, or hopefully we're not likely to see that in real estate, but category 2 offences, these are where there's a failure to comply with a work health and safety duty, and where that failure exposes the person to a risk of death or injury or illness. The penalties are $150,000 for the individual, $300,000 for a director, and $1.5 million for the company. And the last one, and this is the one that we would say is perhaps more likely in our industry, is a failure to comply with a workplace health and safety duty. Perhaps, for example, a failure to consult could lead to a penalty under category 3 offences. Maximum penalty is $50,000 for the individual, $100,000 for a director, and $500,000 for a company. Now, I don't for 1 minute suggest that if you fail to consult with your staff and you are prosecuted under this provision, that the company is going to confront a $300,000 fine. That's a maximum fine, and we would see that the amount of the fine would probably be dependent. We expect it will be dependent upon the seriousness of the breach and whether it's the first of breach or there's some consistency in failing to comply with the Act. So they are the consequences. Now, a PCBU must ensure that the regulator is notified immediately after becoming aware that a notifiable incident has occurred. A notifiable incident is one of the following: a person has been killed, or there's been a serious injury or illness of a person, or a dangerous incident. Now, I won't define extensively what is meant by a serious injury or a dangerous incident, but I'll just quickly explain that a serious injury or illness, and the element of this that could apply in our circumstances in real estate, is where the person has suffered an injury or illness which requires immediate treatment as an inpatient in a hospital. I think the rest of the definition probably isn't relevant, things to do with serious burns and eye injuries and spinal injuries, etc. But I would have thought that there could be occasions where it's possible that one of our employees has an incident at perhaps a vendor's property, or on the way, in a car on the way to a vendor's property, that an accident occurs and that they are required to be hospitalised. That is a notifiable incident. And to not notify leaves you exposed to a breach of the Act. A dangerous incident is one that I really don't think is likely to concern us, but it concerns things to do with uncontrolled explosions or fire, uncontrolled escape of gas or steam and so on. I think that the definition there is likely to have limited application in our industry, but I do think that the serious injury that requires hospitalisation is not beyond the realms of possibility and is worth at least noting. The Act imposes on PCBUs a responsibility that, as far as reasonably practical, you must consult with workers who carry out work for the business or undertaking, who are or are likely to be directly affected by a matter relating to work health and safety. And the maximum penalty here, as I said, is shown on the slide: individual $20,000 and company $100,000. So if the company, if the PCBU and the workers have agreed to procedures for consultation, the consultation must be in accordance with those procedures. Now, again, I draw your attention to a code of practice which deals with workplace health and safety consultation, cooperation and coordination. That can also be found on the WorkCover website. They make this sort of observation, that consultation arrangements should take into account the size of the business, the way work is arranged and what suits your workers. Many workplaces will already have ways to consult on health and safety that suits their needs. These arrangements can continue if they are consistent with the requirements of the Act and the workers have been consulted about them. So the Act gives a high degree of freedom to you to introduce or implement procedures that best suit your business. And before I move to that, the consultation requires that relevant information about the matter is shared with workers and that workers be given a reasonable opportunity to express their views and to raise work health and safety issues in relation to those matters, to contribute to the decision-making process, that the views of workers are taken into account by the PCBU, and that workers are advised of the outcome of the consultation in a timely manner. If the workers are represented by a work health and safety representative, the consultation must involve that representative. I will come in very shortly to talk about the main types of consultation procedures. But when must you consult? Well, you must consult when identifying hazards and assessing risks to health and safety arising from the work being carried out, when making decisions about ways to eliminate or minimise the risks, when making decisions about the adequacy of facilities for the welfare of workers, when proposing changes that may affect the health and safety of workers, when making decisions about the procedures for consulting with workers, resolving work health and safety issues, monitoring the health of workers, monitoring the conditions of the workplace under the management or control of the person of the PCBU, providing information and training to workers. There is, as you can see, a significant obligation imposed by the Act in relation to consultation. But let's look at the three main ways. The first option is what I would call the preferred option, which is to simply consult at staff meetings, at team meetings. It could become a standing agenda item as part of that weekly or fortnightly meeting or monthly meeting, however often you meet. The second option is to elect a workplace health and safety representative. And the third option is to organise a work health and safety committee. Now, clearly options 2 and 3 are going to impose greater administrative burden on the business, and it would be, in our respectful view, option 1 provides the best way of dealing with it. It's not onerous, but it has to be recognised and it has to be implemented. So let's move away now from the legislation. I know that's been extensive and probably difficult to comprehend in its entirety, but let's move from that legislative framework to a more practical consideration of meeting your obligations under the Act. How do you best manage your work health and safety obligations? Well, the first and most fundamental task is for the business to establish its own health and safety management system. And I'm going to draw your attention to the fact that on our people management system, on the Reef people management system, we do have a work health and safety module, management module, that you can access. And inside that module, we have developed a template workplace health and safety management system. So it's there for you to download, it's there for you to customize and to massage and to change to reflect what your business wants. Now, a very important point I'd like to make about the template system. We, of course, have attempted to provide our members with a document that will save you all the trouble, time and expense of putting something together. It's there to be used. I know that there are private providers out in the marketplace who will sell you these sorts of systems for several $1,000s. Well, you don't need to spend several $1,000s because it's provided to you as part of your membership. But, and this is the big but, if you take nothing away from today and you're keen to download that document and implement it as part of your systems, please read the document in its entirety before you finalise its implementation and provide it to your staff. Because once you have released it and you have provided it to your staff, that becomes your policy. And that becomes the expected standard that will be required of you or expected of you moving forward. And if there's something in that policy that you simply can't comply with or a level that you can't meet, it is important that that be changed. So in creating some template or generic document for a multitude of businesses, it can be very difficult. But we do believe, having said that, we do believe that this forms a very solid basis for you to create your own health and safety system, and it sets the platform of what your business is saying to your workers about how seriously you take your health and safety obligations. So the system is there in its entirety. Inside the system, there is a work health and safety policy for a real estate agency. This is the minimum that a business should be doing. We'd like to see every business implement a complete system, but if you don't implement the complete system, you should at least have a work health and safety policy, which is your expression of attitude towards the health and safety responsibilities and obligations. And so every business is required and should have a work health and safety policy. Again, on our website. Thirdly, the next item. As I've already explained, the legislation requires there to be consultation procedures in every PCBU. And inside that management system, you'll find we have developed what we believe is a fairly acceptable and standard consultation procedure that you can adopt. And that is one where you talk to staff through a consultation team meeting approach. You should have some risk management procedure within that health and safety management system. It's appropriate to have some work health and safety induction training for workers. And there's a statement inside that system that talks about that induction training. This slide here is a template form within inside the management system, health and safety management system, which is your induction or instruction record concerning health and safety issues. As you can see from the screen, it talks about the safety rules, for example, around smoking, the use of office equipment, suitable clothing and footwear, accident reports and procedures, first aid kit location, evacuation procedures, erection and removal of signs, residential listing and selling procedures. These are all elements of health and safety that should be, where employees should be instructed on each of these upon their commencement of employment. There ought to be some hazard report form that workers have so that if they do identify a problem, a hazard or a risk, then they have some way of reporting it. Of course, the people management system does allow for an electronic online ability to report such hazards. And lastly on this issue, before we do some practical examples, very important that we start to think about preparing and implementing safe work method statements for particular tasks and activities in real estate. Certainly, safe work method statements are just par for the course in industries where health and safety probably has a higher profile, such as manufacturing, transport, mining, construction, and so forth. You wouldn't undertake any activity in those professions or in those occupations without some safe work method statement. And I think that it's probably appropriate that even in real estate we start to give some consideration to a work health safety safe work method statement for certain activities that we undertake. This is a template form that's within inside that health and safety management system. And I now, sorry, that's the template form. I just want to look at the activities that might appropriately attract your attention for the purposes of a consideration of a safe work method statement. But we have available to members on our website a document that is a checklist of things. If you wanted to listen to today's presentation and you want to go away and say, well, how compliant are we? Is this business operating within the confines of the requirements of this Work Health and Safety Act? We've created a template self-analysis or self-checklist that you can take away and tick off and see where you're okay, where you're not okay, what you might want to change. And that is on our health and safety management system. But in terms of the activities and tasks where we see there are potential risks, one would be erecting and the removal of signs. Now, I know that many businesses now outsource this task, and it's done by third-party providers. But keep in mind, of course, that there are still obligations on the PCBU in relation to contractors. So I'm wondering, those businesses that outsource the task, whether they have sought from the outsourced provider, whether they have established a safe work method statement. Have you seen a safe work method statement from the provider of that service, so that you can be comfortable in the knowledge that they have procedures in place that will protect their workers against a risk from the erection or removal of signs? Clearly, the one that attracts most attention here is property inspections, both selling and in property management. It could be something like a slip or a fall. It could be a road accident. It could be, problems inside the premises, balconies, steps, doors, lighting, whatever it could be, and of course the risk of assault or verbal assault or physical assault from undertaking that particular task. And so we would say that this issue of inspections of property is the one that is likely to create the greatest hazard or risks, or present the greatest risks to the work performed within real estate practice. So what I've done is to, before I get to that, let's not forget, of course, the risk of psychological injury in the workplace. The Work Health and Safety Act would, of course, cover a psychological injury as well as a physical injury. But let's look at this Safe Work Method Statement, which has been prepared, and you'll see that we've got the activity as being property inspection, and the location is various because this will apply generally across the activity of conducting any property inspection. And we have listed down the actual activity associated with the task, and we've got meeting prospective purchasers on site, attending the property alone, the property is vacant, showing prospective purchasers around the property. So there are the various activities or tasks associated with the activity of conducting a property inspection. What are the risks? Well, in item number 1, there is clearly the entrapment risk and the physical assault risk. Now you'll note that we've given, I give each of these various risks a rating from 1 to 3. ratings 1, 2 and 3. Rating 1 is where we believe we can eliminate the hazard and take it away completely. Level 2 is where we substitute the hazard with something which is safer. We can isolate people from the hazard and reduce the risks through some engineering control. And level 3 is where we reduce exposure to the hazard using administrative actions, by giving an instruction or by using personal protective equipment. So I think that with physical assault, we can't completely eliminate it, so it can't be level 1. But we can take some engineering controls to minimise the risk, and therefore I've given it a level 2 rating. What sort of activities, what sort of control measures can we put in place to minimise the risk of entrapment? Well, I've just listed down 4 control measures. You may agree or you may disagree with these. Hopefully you've got other ideas as to what you could do. And if I can now bring this back, having said that, I would like to bring this back to the whole idea of consultation. The preparation of a safe work method statement ideally would be prepared in consultation with those people who are affected by the task, those people who are going out and conducting property inspections. So don't think that the owner or the directors and officers have to be responsible entirely for the preparation or construction of these sorts of documents. They're not. They have ultimate responsibility for implementation. But in terms of preparing of these, the consideration of these, it should be done through the consultation process. So let me just quickly identify the ones that I've come up with, or our staff have come up with. Firstly, just verifying the safety of the area. There are capacities now to download safety alarms to mobile phones that could be used as a safety device in the event of entrapment. Do we identify the people that we're going to go out and meet at a property? On our website, on our people management system, you'll find that there is a client information form where the client is asked to complete just a few basic details so that you can identify them. I always come back to the incident that occurred in Victoria several years ago, where a female salesperson received a phone call from a prospective purchaser because he wanted to see a property. She met him at the property without any identification, without identifying him, met him at the property. He subsequently murdered the salesperson. Yes, that's extreme. Yes, that's not common. But it has happened. And the fact that it has happened gives us little excuse to say, well, we didn't think that that was a possibility. So to say that it wasn't reasonably practicable for us to consider the risks of assault, I think would fail, the pub test, because quite clearly there have been assaults, there have been murders in real estate, and so we need to recognise that that is a risk, and what steps and what procedures we adopt is entirely a matter for the business. I'm not for 1 minute trying to suggest, please I hope not taking it this way, I'm not suggesting that you have to implement, for example, the client information form. I'm proposing it as an option for your business's consideration. Another one might be no after dark inspections. May be possible, may not, but it's certainly worthy of consideration. And I know that there are many businesses who have that policy in place. In terms of attending the property alone, this is item number 2, the property is vacant. Well, again, we've got the entrapment risk from the person outside the home, level risk 2. Before entering the property, check for signs of break-in or disturbance, such as broken glass or open doors and windows, and follow the other items that I've listed in one above. Showing prospective purchasers around the property. What are the risks there? Well, I think the most obvious ones will be slips or falls on uneven, wet or unsealed ground. There might be some aggressive animal that exists in the backyard. So what sort of things what control measures can you take there? Well, rubber-soled shoes must be worn. Women must not wear high heels. Warn prospective purchasers of any hazards associated with structures on the property. These are mossy surfaces on driveway, which is particularly slippery when wet. Steps at the back door are in poor condition. And before entering the property, ensure with the owner that the animal has been properly retained. Now, they are but some ideas for considerations, I've said. There probably are other risks that you can come up with, and I'm sure there are going to be other control measures that you can come up with. But at least, hopefully, this gets you thinking about that process. Driving to and from inspections, well, of course, the likely risk there is a road accident, and I put that as a level risk 3. We can't eliminate it completely, of course, but maybe through some administrative actions, some policies, we can minimise the chances of there being an accident by providing instructions about obeying road rules, including speed limits, not driving under the influence of alcohol or prescribed medication where it affects your ability to drive, and absolutely no use of mobile phones unless hands-free is available. They're the sorts of control measures that I think are fairly fundamental, and they might seem like common sense, and yes, they are. But if you have detailed them and staff have been told about them, that this is your level of expectation, then you provide yourself with a very strong level of cover in the event of something going wrong. Items 5, I haven't provided details on these, but conducting an open inspection, putting out open for inspection signs, and erecting for sale signs. So they're 7 sort of tasks that we would say are fairly common in real estate and ought to be considered. Another one, this is another one I did just yesterday in preparation for today's webinar that I thought might be helpful, and that's property prospecting, where we have people going around the suburbs either doing letterbox drops or door knocking. Clearly, there are going to be certain hazards and risks that such workers will confront. So you've got the travel to the prospecting area. You've got the dangers of a road accident, being hit by a car, or if they're on a bike, whatever. So there are certain control measures that I've sought to put in there. Obeying road rules, of course, absolutely no use of mobile phones, prospecting after dark, no prospecting after dark, and I think advising the office of when the prospecting has concluded and perhaps the worker's going home or has arrived home, or clearly they come back to the office, but if they're not coming back to the office, they're going home, I think it would be very sensible to have some control measure that they must ring the office once they have safely returned home. You've got entrapment risks, of course, whilst this activity is being undertaken, either from inside or outside the home. So we've got things there about safety alarms on mobiles. Before entering the property, check for signs of break-in or disturbance. Make sure they're be contactable at all times, so they're carrying a mobile phone. Organising some code word with the office if the worker felt they were in some sort of dangerous situation, some entrapment situation, they could phone the office and there's a code word that you would recognise as being that they need someone to go out there and to help them. It could be, as one agent did many years ago, said the code word was purple folder. So if they said that they needed the purple folder, that meant they needed someone to come out and give them some assistance. So there's that idea. The physical effects, of course, being out doing this sort of work, sunscreen and hats must be worn, water bottles must be carried. Perhaps you put a policy, a control measure in place which says that there'll be no prospecting between 12 and 4, which is the hottest part of the day. Must wear rubber-soled shoes, women not to wear high heels, and so on. So there are some ideas around those sorts of activities in real estate. Now, that concludes the formal part of the presentation. I hope that the legislative elements didn't send you to sleep too deeply. I hope that applying the practical elements within real estate practice to that legislative framework gives it a bit more of a practical feel, a day-to-day feel. Josh, I don't know whether we have any questions that have come in from people that I'm happy to try and deal with.
We haven't had any come through, so
that's either a very good sign or a very bad sign. So, ladies and gentlemen, I thank you very much for your participation and for viewing in this morning. As I said, this is the last of the employment webinars for 2016. I understand that we'll be looking at another program in 2017, and I look forward to your company at that point. Thank you.
All right. Thank you for participating in our webinar today on REEF Workplace Health and Safety. Please complete the survey at the end of the webinar as RINSW values your feedback. Thank you.